Okay, let's unpack this. We are diving into a legal conflict that really gets right to the heart of what we value most. I mean, the tension between someone's property rights, which feel deeply personal, and the absolute sanctity of human life. This is where the law draws a very bright line. Often in the face of, incredible frustration and anger, we're looking at what happens when an owner, just tired of being continually tormented by thieves and trespassers, decides enough is enough and resorts to extreme self-help. We're talking deadly mechanical traps here. The goal of this deep dive is to see precisely where the legal system says, hold on, you cannot inflict serious injuries simply to protect your belongings.
And we have, really, the perfect vehicle to guide us through this. It's the iconic Iowa Supreme Court case, Kotko v. Brainy. To fully grasp the impact of that ruling, we really need to structure our discussion logically. We'll start with the foundational, or, as lawyers call it, the black letter rule governing the use of force to protect property. Then we'll move into the specifics of Katko, analyzing the facts, the court's reasoning, and, of course, the final judgment. And finally, we'll test the principle with a pretty visceral hypothetical. That should give you a clear diagnostic framework to handle any similar situation you might encounter.
Right. Let's start at the bedrock then. Given how common things like trespassing and theft unfortunately are, what is a foundational rule regarding an owner's right to use force, I mean any force, to protect their land or what we call chattels? And maybe just quickly, for those unfamiliar, chattels just means your movable personal property, right?
Yeah.
Your stuff.
Exactly, and that's a crucial starting point. The general rule, which comes from, well, centuries of common law and is synthesized by authorities like Prosser and the Restatement of Torts, seems straightforward on its face. It says one may use reasonable force to protect property, but, and this is a key, that phrase reasonable force is severely qualified. The established standard is that an owner may not use force, whether they're actually present or acting indirectly through some kind of mechanism that is calculated or reasonably likely to cause death or great bodily injury, merely to repel a threat to land or chattels.
Okay, so just to make that concrete, if someone is simply walking across my lawn, I can yell at them, maybe, gently push them off the property. But I absolutely cannot use, say, a baseball bat to break their kneecap, even if they're ignoring me telling them to leave.
That's exactly right. And the policy reason behind this is really what matters most here. The law consistently maintains that it places a higher value upon human safety than upon mere rights in property.
Hmm.
So therefore, deadly force is only ever justified if the intrusion poses an accompanying threat to the defendant's personal safety, or if the intruder is committing a felony that itself involves violence or endangers human life. Simple theft or trespass, just standing alone, they simply do not meet that high threshold.
It's easy to agree with that rule in theory, sitting here talking about it, where everything's tidy and abstract. But the emotional conflict in Katko v. Brainy really shows why this principle can be so difficult, so raw in real life. Let's look at the actual facts of this case. Let's analyze Katko v. Brainy. First, what were the legally dispositive facts?
Okay, so the setting is this rural 80-acre piece of land in Iowa. The defendants, the Braineys, they owned an old farmhouse there. But importantly, it had been completely unoccupied for several years, and it was actually miles away from where they lived. Now, the key emotional context, and you mentioned this earlier, is that for almost 10 years, the Brinies were just plagued by constant trespassing and break-ins. They'd boarded up windows, they'd posted no trespassing signs, and yet people kept getting in and stealing stuff, mostly kind of junk, old bottles, fruit jars, things like that. So in June 1967, Mr. Brainy basically reached a breaking point. He later admitted he was, quote, mad and tired of being tormented. So he set up a booby trap, was in the north bedroom. He took a loaded 20-gauge shotgun, secured it to an iron bed, and rigged a wire from the doorknob to the trigger. The initial setup aimed high, toward the torso, but apparently at Mrs. Briney's suggestion, he lowered the barrel so it would hit an intruder's legs instead. And crucially, there was no warning sign posted outside about the trap. So the plaintiff, Marvin Katko, he entered the house. He pried off a board from a window, intending to steal some of those antique bottles he'd seen before. Yeah. When he opened that north bedroom door, the gun fired, hitting him in the right leg. It caused a really severe injury. Part of his tibia, the shin bone, was literally blown away.
Wow. Okay, I have to stop you there for a second. Because this sounds like an extreme case of self-help, yes, but it's motivated by years of documented harassment, right? I mean, the Brinies are trying everything they can think of to stop people from illegally entering their property and stealing. Does the law really expect them to just keep waiting for the next break-in? Just keep absorbing the property loss and having their place violated?
And that is precisely the tension the court had to grapple with. They absolutely acknowledged the Brinies' deep frustration I mean, who wouldn't be frustrated? However, the law insists that civil remedies, things like suing for trespass, pursuing criminal charges, these must be used instead of lethal self-help when only property is at stake. The Briney's subjective feeling of being tormented, however real, it simply doesn't legally justify the objective use of deadly force.
Okay, that definitely sets the stage for the legal challenge. So what was the core legal issue that the Iowa Supreme Court had to resolve here?
Right. The primary issue was actually very narrowly focused by the court. It was, may an owner protect personal property, specifically within an unoccupied and boarded up farmhouse, against trespassers and thieves by setting up a spring gun capable of inflicting death or serious injury? The court really stressed that unoccupied part. They explicitly said they were not deciding a person's right to protect an inhabited home or their family within it. That's a different scenario.
Got it. So given they were dealing with, well, a classic booby trap situation,
Yeah.
what rule did the court apply to figure out if the Bryanies were liable?
The court basically affirmed the strict traditional rule that had been developing for a long time. That rule is spring guns and similar dangerous devices are pretty much universally prohibited unless they are used to prevent felonies of violence or in those rare situations where human life itself is imminently in danger. A really key factor in their reasoning was how they classified the crime Katko was committing. Breaking and entering to steal property in this specific context of an unoccupied building was determined not to be a felony of violence, nor was it the kind of crime punishable by death back then. Therefore, using force capable of causing death or serious injury was impermissible.
Okay, so that's the rule they applied. What was the court's analysis? What was the actual logic that convinced the court the Bryanies were liable, even though, let's face it, the plaintiff, Katko, was clearly doing something wrong? He was trespassing and intending to steal.
Yeah, and the court acknowledged Katko was a wrongdoer. But their analysis relied heavily on this principle of, well, you could call it vicarious action. The core idea is that you cannot delegate lethal force to a machine when you couldn't legally use that same force yourself if you were standing there. The court put it like this. The landowner cannot do indirectly and by a mechanical device that which, were he present, he could not do immediately and in person. So since the Bryanies could not have legally stood in that room and shot Marvin Katko in the legs for stealing old fruit jars, they couldn't set a trap to do the exact same thing. The court pointed to an overwhelming weight of legal precedent supporting this view. They stressed that the intent behind setting the trap, even lowering it to hit the legs, was still calculated to cause great bodily harm. And they relied on a policy statement from an older case, Hooker v. Miller, which basically emphasized that trespassers and petty thieves, while wrong, are not to be visited by barbarous punishments or prevented by inhuman inflictions of bodily injuries. Bottom line, the force used was just completely out of proportion to the crime being committed.
And the conclusion. What was the final outcome?
The lower court's judgment, which had been in favor of the plaintiff, Marvin Katko, was affirmed. The Iowa Supreme Court held that setting the spring gun was unlawful because the force used was disproportionate to the threat it was calculated to inflict great bodily injury simply to protect mere property rights in an unoccupied building.
Okay, that case is very clear when the device is obviously dangerous, like a loaded shotgun. But let's test the real boundaries of this rule, specifically that great bodily injury standard. Let's use maybe a more visceral hypothetical. Imagine a frustrated homeowner. They're tired of people climbing into their attic, maybe through a window, to steal valuable, rare comic books. Big collection up there. They don't use a gun. Instead, they rig up a large, sharp industrial fan just inside the attic door. It's set to activate instantly when the door is even slightly opened. The clear intent is to slice the fingers off any intruder trying to get in. And the homeowner argues, look, it wasn't a gun. It wasn't intended to kill, just to wound severely and permanently. I just wanted them to stop stealing my valuable collection. How does the rule apply there?
That's a great hypothetical because it really pushes us to define great bodily injury and look beyond just firearms. This scenario is perfect for illustrating the actual scope of the Katko principle. The key, again, isn't the type of mechanism, whether it's a gun, a fan, a blade, poison, whatever. It's about the likelihood and severity of the resulting harm. So the question becomes, is permanent maiming, like having your finger sliced off, considered great bodily injury? And the answer is unequivocally yes, absolutely. The law generally defines great bodily injury as something that creates a substantial risk of death, or causes serious permanent disfigurement, or results in protracted loss or impairment of the function of any bodily member or organ. Permanently losing the function of your fingers, your hands. That easily meets the test for serious permanent disfigurement and loss of function.
Okay, so if I'm tracking this right, the severity of the likely injury is the key factor, the key multiplier, regardless of the specific device used. The homeowner, in our hypo, might not have intended to kill, but because they set a device that was reasonably calculated to cause permanent disfigurement or loss of limb function just to stop a property crime, that force is still prohibited. It's disproportionate, just like the shotgun in Cutco.
Precisely. You've got it. If the threat is purely about the theft of property, even highly valuable property like a rare comic book collection, the owner cannot legally justify using a level of force that results in permanent disfigurement or serious lasting harm. You're just not allowed to use force that inflicts suffering that is so wildly out of proportion to the threat you're facing. The principle holds firm. Life and limb trump chattels every single time.
That really brings the whole doctrine into sharp focus. It's quite stark when you put it like that. So let's wrap this deep dive up by maybe creating an actionable step-by-step diagnostic tool for our listeners. What does all this mean for someone, say, facing a defensive property question on an exam or just trying to understand these situations? How do we structure the analysis using everything we've discussed?
Okay, absolutely. The rule established by CATCO and supported by, broader authorities like the restatement gives us a pretty concrete four-step diagnostic checklist. This should help you analyze any defensive property situation involving serious injury. First, identify the force. You have to ask, was the force used, whether it was direct personal force or indirect through a device, intended or likely to cause death or serious bodily injury? You need to establish that this high threshold of potential injury was met. A 20-gauge shotgun, clearly yes. An industrial fan set to slice off fingers? Also, clearly yes. Second, identify the threat. What was the underlying threat, really? Was it one of pure property damage or theft? Or, crucially, was there also a direct and immediate threat to the personal safety of the occupants or maybe users of the premises? In CATCO, it was purely a property threat against an uninhabited empty building. That fact dramatically lowers the amount of force allowed. Third, characterize the intrusion. If a crime was being committed, like trespassing or breaking and entering, was it specifically a felony of violence? Or was it a crime that, by its nature, was demonstrably endangering human life? If the crime is only theft or nonviolent breaking and entering, like in CATCO, then deadly or seriously injurious force is prohibited. Fourth, and this is really the ultimate tiebreaker, the core CATCO test, proportionate force test. Ask yourself, could the owner, if they were present in person and fully aware of the intruder's nonviolent intent, like just stealing jars, have legally inflicted the same level of injury on that intruder? If the owner could not legally shoot the thief or slice off their fingers directly, then they absolutely cannot set a trap to achieve that same result indirectly.
So the ultimate lesson here, the sort of aha moment maybe, is that the law doesn't really care about the Briney's years of understandable frustration, or even the clear moral failure of Marvin Cutco as a thief. It cares primarily, maybe even solely in this context, about the absolute systemic value the legal system places on human life over, as the court said, mere rights in property. That must have been an incredibly difficult pill for the Brineys to swallow. I mean, they were essentially punished quite significantly for trying, however misguidedly, to defend their own land.
Oh, undoubtedly. It was incredibly difficult for them financially and emotionally, and their situation really reflects the deep frustration many property owners feel when they feel helpless against repeated intrusions. But if we connect this legal doctrine to the bigger picture, thinking about policy, this legal principle serves a critical function for maintaining social order. Think about it. If the law permitted individuals to set lethal or maiming traps for relatively minor property crimes, wouldn't society become fundamentally more violent, more unstable, probably less predictable? This prohibition against using excessive force, it protects not only the individual wrongdoer from, frankly, barbarous punishment, but it also solidifies a necessary common valuation of human life. It forces civil society, ideally, to rely on the courts and law enforcement, not hidden traps and vigilantism, to enforce property rights. And that's a policy judgment that applies even when the trespasser is clearly morally in the wrong.